Hi, everyone. We're just going to give it a few seconds for the room to fill, and then we will get started. All right, everyone. So I'm going to kick it off. Welcome to the Dallas Association of Young Lawyers Deposition Ethics CLE. My name is Kathy Yukovich. I am an associate at Tillotson, Johnson, and Patton, and it is my great privilege to moderate and hopefully say very little during today's CLE. I'm going to start with a brief introduction of our panelists, and then I will kick it over to them. So first, we have Kelly Hinson. Kelly is a partner at Carrington Coleman. She has handled claims against lawyers and law firms from almost every angle. She has represented other lawyers and major law firms around the country, served as general counsel, and I believe still serves as general counsel at Carrington Coleman, and sits on the Dallas Grievance Committee and the Texas Board of Disciplinary Appeals. Next, we have Paul Koning. Paul is a partner and founder at Koning and Rubarts, and for more than 35 years, Paul has represented top law firms and lawyers regarding claims of professional misconduct, legal malpractice, and breach of fiduciary duty. He has also represented lawyers in the face of grievance complaints and disbarment. Hopefully you never find yourself as a client of Paul's. Paul has dedicated a substantial amount of time and effort to the enhancement of professional responsibility and best practices for lawyers in Texas. In 2021, the Supreme Court of Texas designated him as chair of the Texas Professional Ethics Committee, which is the 9-member body charged with drafting legal ethics opinions for lawyers. Next, we have Robert Tobey. Robert is a partner and founder at Johnston, Tobey and Baruch. Robert served as the 2020 president of the Dallas Bar Association and presently serves as an elected director on the State Bar of Texas Board of Directors. He has repeatedly been selected as Lawyer of the Year in legal malpractice law by Best Lawyers in America, and from reviewing his bio this week, has won enough awards to fill the entire hour of our CLE. Next, we have Lindsay Wyrick. Lindsay is a member at Cobb Martinez Woodward. She is best known for her representation of lawyers, CPAs, and other professionals in all aspects of litigation and administrative proceedings, with a particular focus on ethics issues, professional regulations, and risk management. She also works on emerging technology and cybersecurity issues. So we are thrilled to have such a wonderful panel with such a breadth of experience to hopefully keep all of us out of hot water. And while I hope the best for all of their businesses, hopefully keep all of us out of their client seat as well. I am going to kick it off with hopefully my one and only story, which is my very first deposition. So when I was a first-year lawyer, I got to my very first deposition in Kentucky State Court on a slip and fall case. I walked into the deposition room, and after the lawyer on the other side announced to the witnesses in the room that I was a big city lawyer and had probably flown there on a private jet, asked me if I wanted to take the deposition according to the rules. And I said, "What rules?" And the deposition proceeded from there. So hopefully you will not make the mistake that I made in my first deposition, which is not fully understanding what that question might mean. And you will be fully versed on all of the rules that apply to you and your clients as you go forward in your practice. So I want to start with Kelly and ask this question, and I'll be asking it of all of our panelists, is what is something that you remember from your very first or one of your early depositions where you faced an ethical issue, and how did you deal with it then? And what advice would you give your young lawyer self now?
Yeah, when you asked this question the other day, the situation that came to mind was one of my first depos. I was defending the depositions of 3 lower level employees of our client, our corporate client. And it's the first deposition that I've defended, and we get in there, and one of the very first questions that the other lawyer asked is Miss Henson representing you? And I didn't know what the witness was going to say. I was, waiting to hear the answer. I thought it was something I should have thought about. The witness said no, that I didn't represent her. And so then the opposing lawyer started to ask all these questions about what we'd talked about and what I had done to prepare her and what did she know about the case. And I was just trying to figure out if I could object, if it was privileged. Anyway, it was this most stressful half hour of a deposition I've ever sat through. So what I would advise my younger self is to think about that question before you walk into the room and, think about how you're going to handle it. Are you representing the witness or are you not? And if you're not, is there still a privilege because they're a representative of your client? And so just sort of think through those issues before you get caught on the fly. And we're going to talk about some of those issues later this afternoon.
Yeah, it seems incredibly simple, but I feel like often simple things will really trip us up. So I did forget to mention two things. The first is I will be putting the CLE code, the ethics CLE code in the chat at the end of the CLE. And the second is if you do have any questions for our panelists, you are not able to unmute yourself and pipe in, please just type them into the Q&A function and I will categorize them and get to them. So the next person that I want to turn to is Paul. Paul, is there an issue or something that you see young lawyers running into frequently, advice that you might give your younger self?
Well, from when I was a younger self, things were very different. We had depositions in smoke-filled rooms full of cigarette smoke. They lasted forever. There were no time limits. And people made speaking objections that were almost as long as the depositions themselves. And so I don't really remember very much from back then. I remember a couple of fist fights that lawyers got into. I don't see that as much anymore. My recommendation to everyone is that generally preparation is the key to having a successful deposition or having one where you don't get hurt as badly as you might otherwise get. Your witnesses are going to be more nervous than you are, and so part of your job is to reassure them and explain the process carefully so that they don't freak out if something goes weird. But that's all I got.
Robert, what about you? Do you have a story from your earlier years of practice or advice that you might give yourself?
Many, but let me just focus in on one. And I was a young pup, and this was a construction defect case. And like all construction defect cases, even going back this many years, there were a bunch of defendants and a zillion witnesses. And so we were in a deposition that impacted my client, but I was not the lead lawyer in the deposition. And the lawyer who was taking the lead established a point probably pretty well. And I guess I was determined to sort of pound that point home to show I belonged. And I went back in and asked that witness on the same topic a question where the witness was able to waffle. And I basically got my butt chewed out after that deposition. And I learned a lesson very early on. Just because you really feel like you have to show off how smart you are, sometimes it's better not to do that. And so the practice point there is coordination. If you're in a multi-party case and somebody else besides you is taking the lead, make sure you coordinate whatever it is you're going to ask that witness with the party who's taking the lead, so you don't do something that undercuts them and results in a phone call to the lawyer who is managing you over at your law firm. And maybe unkind things are said. Let's just leave it at that. So coordination, think before you speak. Don't feel like you have to show the world just how smart you are every chance you get.
At the risk of violating your advice, I will go straight to Lindsay. Lindsay, do you have any story or advice that you would share with your younger self?
Yeah, so one story that jumped out is early in my career, I was involved in a Ponzi scheme case where we were representing an accounting firm that was sued as part of that case. And we were presenting a CPA for deposition, and we had prepared this CPA, several times and thought he was ready, and things were going fine in the deposition until that last hour. And the plaintiff's lawyer really went into that rapid fire examination mode, and our client just cratered and admitted negligence, not only for himself, but brought in, said that he had discussed the matter with others and implicated others at the firm in his testimony. And so it was really, detrimental to the case. And so that's just a reminder that the deposition's not over until it's over. You not only want to prepare your client ahead of time, but you need to prepare them throughout the day. And often that last hour when they are tired is really one of the most critical to stay focused. So you've got to prepare them for a long day and make sure they stay focused and engaged.
I mean, it's when they are tired, and it is often when you are tired as well, right? You have been preparing them, you have been focused, so that last hour can be quite dangerous. So thank you all for sharing what are sometimes vulnerable stories about your earlier years. So I want to shift gears now to preparation of witnesses before depositions. Often as junior, mid-level lawyers, you are asked to not always take the apex deposition, but prepare and defend your client or representatives of your client for their depositions and then defend those. So Paul, I want to turn first to you. I'm going to put ABA Opinion 508 up on the screen so folks can see it. But I was hoping that you could walk us through some guidelines that we should know about and just give us sort of the big picture of, as young lawyers and as lawyers in general, what we should be focused on and what we should be paying attention to.
Sure. Well, I've come at this more from an ethics standpoint, and ABA Opinion 508 is pretty recent. It talks about, it gives guidelines as to what is okay to do in preparation and what is not okay. And I just asked to have this put up on the screen, so if anybody wants to look at it later, you can easily find it. But they have a list here of some fairly obvious things that are okay. Reminding people they will be under oath, reminding people to tell the truth, reminding or telling people that it's okay to say truthfully, I don't recall, or I don't know. And I say truthfully because one of the reasons this opinion came out was there was quite a bit of attention at the time to Cassidy Hutchinson, who had testified before the January 6th committee and who told the press that she had been advised by her lawyer that she should just say she didn't remember everything, and that she couldn't be accused of perjury if she just said she didn't remember everything. And that is very questionable advice, and this opinion then goes into that later. Providing context is telling what the issues in the case are, inquiring about the witness's probable testimony. All those things are very acceptable and normal. And one would suggest you even have an ethical duty, if this is your client that you're preparing, to go into all these things to get the client prepared for the deposition. It's not on the sheet, but reviewing documents with the client, reviewing key documents is also important. There is a little bit of a catch there under Rule 612, the evidence rules regarding refreshing the witness's recollection, and specifically Rule 612 provides that if the witness refreshes the witness's recollection with a document, the court has discretion to order that document be produced if it's in preparation. If it happens during the deposition, then the document has to be turned over. Typical advice includes, don't speculate, wait to answer your question till the question is completed. Think about your answer and compose it in your head before you give it. Don't volunteer information beyond the scope of the witness's testimony. Those types of preparatory warnings are all very much appropriate and acceptable. And so I would just encourage people, look at Opinion 508 if you want a good starting point for a definition of what's appropriate to prepare your witness, and then talk to your superiors, the people you're working with, to get some other guidelines as well. That's all I got.
Thanks, Paul. I think that overview is really helpful on what's okay. And I think we're going to shift a bit to get to where you walk a bit up to the line or what's not okay. So I want to turn first to Kelly. Kelly, what is one or two areas where you have seen lawyers get into trouble in preparation? In general areas or examples that you have of folks walking right up to that line and then crossing it?
Yeah, I think the line between being a vigorous and effective advocate and crossing the line into inappropriately coaching your witness can be gray sometimes. I think this ABA opinion is really helpful in some of the things that it says are okay. In addition to some of the things that Paul mentioned, it also says that you can provide context for the witness's testimony. So you can tell them, here's what the case is about, and here's where your testimony fits into the case. Here's why it's important. And it says you can identify other testimony that's expected to be presented. So that says to me, you can even say, you should know that Bob is going to say X, and Jerry is going to say Y, but I want to hear your version of events. And it says that you can suggest the choice of words that might be employed to make the witness's meaning clear. But then, when it gets into unethical coaching, one of the things is programming the witness's testimony or encouraging them to present fabricated testimony. Those are the no-nos, but, telling them what other people are going to say, giving them context, helping them with word choice is okay. And I think the line between those two groups of activities can be, a little hard to draw. A lot of times witnesses, if they're lay people especially, want to use words that have meaning in, to lawyers that they might not understand. Like they might want to say that someone committed fraud. And I think it's okay to say, let me tell you what fraud means. Is that what you're meaning to say? Or do you, there's a difference between fraudulently inducing someone, for example, to enter into a contract and saying they made promises that they ended up not fulfilling. That may not necessarily be fraud, but I don't think witnesses, can make those fine distinctions sometimes. So, where do you draw the line between explaining to them what their words mean and the effect those words are having on the case and coaching them into saying something that they don't really believe? And so you need to be really careful when you're stepping up close to that line, because as many times as you say, and I say multiple times during a prep session, tell the truth, tell the truth, tell the truth, that can sometimes be taken, the witnesses may think you're giving a little wink when you're saying, but here's the really important word I need you to say or to not say. And so you just need to be really careful that you don't intentionally or unintentionally push the witness into saying something that they don't believe or that it's not true.
Let me add on to that. I think I didn't mean to interrupt you. Were you finished, Kelly? Or
Yes.
So here's kind of, as I read that opinion for the first time a year or so ago when it came out, I started thinking, imagine you're representing the plaintiff and the plaintiff is suing for fraud, and you're relying on the discovery rule because more than 4 years has gone by since the alleged misrepresentation was made. And let's just say that the case was filed 3 years and 364 days after you allegedly discovered the fraud. And you're prepping the witness and you explain, there's a 4-year statute of limitations on fraud. That's perfectly okay. And it's perfectly okay to say that limitations can be told until you have discovered, or in the exercise of reasonable diligence, should have discovered the misrepresentation. You can tell them that. That's okay. And then you get right up to the line where the date of filing, and the other lawyer is going to be pushing your witness on when it is they discovered or should have discovered the alleged misrepresentation. And it's probably okay to say, you understand that you've told us that you discovered it on whatever date, 3 years and 364 days before the lawsuit was filed. But then I don't think you can then go on and say, under no circumstances ever admit that you discovered it 1 day earlier than what we've said. And so it's really nuanced. It is a very gray line at the edge, but you anticipate where the weak spots are in your case and where the other side's going to push. And you've got to be very careful not to tell the witness, under no circumstances say this, because it is really tempting. You could even say, if you admit that you discovered it 1 day earlier, you're going to lose the case. That might actually be okay to say that, but it's really nuanced and really gray. And I appreciate hearing everybody else's thoughts on that in terms of where the line is. You just can't tell them, don't say that. That's over the line.
I don't think you can say to somebody, if you say that, you're going to lose your case.
I think you can. I think you can say, you understand the discovery rule only applies, and here's the date you discovered it allegedly, and here's the date we filed suit.
No, I'm saying, if the person says, I found out about this January 1st, and you cannot say, if you testify to that, you lose your case, because that's encouraging them to change their testimony to win their case. That's implicit in that. And I think there's actually, if it's not in this opinion, there are, I've seen it in other articles where that specific instruction or comment to the witness is held to be encouraging perjury.
Well, what about the flip side though? And I think there might be maybe there's some nuance here. Paul or Lindsay, I'd like to get your thoughts. Maybe there's not, but it seems to be what Robert is saying is, you've told us before that your claim fits in the statute of limitations. If you vary from that testimony, you'll lose. Versus they say, hey, my claim doesn't fit in the statute of limitations. And then you tell them, if you say that, you will lose. Is there a difference in your mind, or are we in that gray area? Lindsay or Paul, what do you think?
Well, I think it's okay to tell them about what the issues are in the case, and that's an issue. And if they have told you what they know about it, and you can still say, well, that's great, that fits in with our theory of the case. But the problem comes up is when they tell you their recollection of facts that doesn't fit what you want for the case, and then you tell them, hey, you better you better understand that if you say that, Mr. Witness, you're going to lose the case. I think that crosses the line. That's just my opinion.
Well, you've changed what I said a little bit, because you've inserted the fact that now they're telling you in the prep session, oh, I actually discovered it earlier than what we're saying in the lawsuit. I agree with you on that. If they tell you that, I do think that is encouraging them to lie in their deposition. I would agree with that.
Lindsay, let me ask you this question, because I think that this situation in some form or fashion will come up for all of us. And maybe it's a statute of limitations issue, so we'll keep going on that example. So let's say that for years, your client has said they discovered the fraud or the misrepresentation on January 1st. They have been consistent. They have told you that over and over again. You've got notes, you've got interviews. You are confident in that fact. And they come into their prep session and you guys are going through and they say, actually, I discovered, they say, I think I discovered on December 1st. Are you in the clear to without saying that you lose your case, can you say something like, we've had several meetings and you've always told me it's January 1st. Is that something, does that walk the line of encouraging them to change their testimony? Sometimes people just forget things or misstate things. What do you think?
Yeah, I mean, I think you have to help them find out what the real truth is there. I mean, that's your job, is to prepare them for truthful testimony. And so, and maybe there's documents or other information or other witnesses that you can go to at that point and try to really piece things together. But you want to help them figure out what is the real truth for their testimony. And I'll just add, in my experience, most witnesses, come in with their truth, and they stick to that. And so, it's important, as Kelly and Paul pointed out, to arm them with language that may be helpful to use in their testimony. But their truth is their truth. And a lot of times, even if you sort of discuss it in different ways or context, you get to the deposition and they say it exactly as they came in and said it, right? Oops, sorry, I lost my line. Right at the beginning of the meeting. And so, that's your goal, is to help them prepare for their truthful testimony. And if they're waffling on what that is, then you want to help them figure that out in the prep.
I had a lawyer tell me when I was a young lawyer that when litigation is filed, truth is the first casualty. And so you will encounter people, as Lindsay says, who tell you their truth. And they could pass a lie detector test on it, even if it's demonstrably false. That is kind of the subtext of what we deal with all day long, every day in our cases, is that it's the truth as people perceive it. It's the truth as people have decided it must have been because they were hurt in some way. And that's a challenge. That's a real challenge for all of us to deal with.
Kelly, let me ask you the flip side of what we've been talking about a little bit, which is, is it okay for you to go into the prep understanding that the ABA opinion and other ethics opinions allow you to provide context and to help folks understand, what words to use? Is it okay for you to say, if you say X, if you say A, B, and C, we have the best chance of winning, or you have the best chance of winning, or you will defeat X claim? Or does that level of prescription cross an ethical line?
I think it depends on the circumstance. I mean, I agree with Lindsay that your job is to prepare your witness to tell the truth. And so I think helping them figure out the truth is appropriate. If they come in and say, this is my memory of how things went, but you have a bunch of documents that show their memory is wrong, I don't think there's anything wrong with, okay, let's explore. I don't want you to guess about what happened. Let's, explore some of these documents and look at them and see if they change your mind. If they don't, that's fine. But I want you to, really think about what you're going to say before you say it. And, if it's a word choice issue, I think it's, fair to explain to them the effect that one word versus another might have. But again, pushing them towards the truth. It's sort of a subjective state of mind for the lawyer. If you're trying to get them to say something that they don't believe, then that's unethical. But if you're, helping them to figure out what the truth is, helping them to frame their truth in a way that they can testify about, I think that's appropriate. So it sort of goes to your state of mind and what you're trying to accomplish.
And before we, move on from this topic, let me ask, I know that we all hope and believe that our clients are angels and that we are as well. But assume with me for a moment that you have a client when you ask, did you have a conversation with X person about Y topic? And they say in response to you, of course, I had a conversation with X person about Y topic. What else do you think we talked about in that conversation? How do you respond to a client that it seems to be taking cues from your questions? And what do you do in that situation? And anyone who wants to speak on the question.
I have had to tell witnesses before, don't tell me what you think I want to hear. I really am trying to get your view of what happened. And, well, what would be better for our case? Well,
Yeah.
that's not the issue. Tell me what happened and then we'll work from there.
Cassie has identified a personality type, and there are going to be people like that. I represented somebody just like that not long ago. And the preparation for her deposition was maybe one of the worst experiences I ever had as a lawyer in 40 plus years. It was just horrible. And I guess I'll say this. In our prep, I was asking her some questions, kind of playing the other side. And she lied to me in the prep. And so we stopped and she goes, well, that isn't true. I said, why the heck would you lie to me in a prep session? We don't have the other side here. Tell me what happened. And I've come to realize over the years that some people are bad witnesses, and you can prep them as much as you want, and they might do well for 15 minutes, but whatever caused them to be a bad witness will come out over the course of multiple hours. And so all you can do is the best you can do. And with some people, there's some people who are really good at it and are A witnesses. There's not many of those. There's quite a few that are B witnesses, and many get failing grades. And all you can do is the best you can do. And people like that are looking for cues, not only from you, but from the other lawyer when they're questioned. All you can do is try to do what Kelly said, which is just tell me what happened. But it's hard for some people.
I'll just add to, and this sort of goes into another topic, but on the same lines, but in this day and age, we have so many documents related to the conversations, whether it's emails, texts, chats, notes, whatever. And so, arming your witness with documents and a timeline can really help build out the truth and how things unfolded. And so, we always share with our witnesses key documents, in chronological order to help them build out that timeline. And oftentimes, if they're waffling on something or they misremember something, going back to the documents can really help them prepare for their testimony. Now, on the flip side of that, what Paul mentioned is you want to keep those documents protected because a lot of times you'll get the question in the deposition to your witness, what did you do to prepare and what documents did you look at? And, we want to take the position that the documents we prepare and provide to our witness in preparation are protected by the attorney-client privilege or the attorney work product privilege. But if the witness takes the position that they use those documents to refresh their recollection for the deposition, they may be discoverable. And so that's just something to talk through with your witness and have them prepared on. But a lot of times we really go back to the documents to help the witness prepare.
And Paul, I saw you smiling when I gave my example and Robert said that I had identified a particular type of personality, perhaps. Do you have any advice for young lawyers or newer lawyers or any lawyer really, who's dealing with a client that really is willing to take cues or is really looking for what you want them to say.
Takes a certain amount of emotional intelligence to recognize that personality type. I'm not sure I've got it, but if it's somebody who's looking to you to tell them what to say, needs to be challenged and made to think differently about the person's role. But as Robert says, sometimes there's no changing people. People that are bad in prep sessions, doesn't matter how long you can prep them all day, and they'll still fall apart in the deposition. So and I agree 100% with what Lindsay was saying about the use of documents. Usually, in most complex cases, there's the documents. If you're in a car crash case, maybe it's not, but in a document-intensive case, the witnesses will follow what's written. And it's your job to have that all put together before you start preparing them so that they don't get surprised during their deposition or they don't testify contrary to what's in the documents.
Yeah, I
Lindsay,
listened
go
to
ahead.
a really interesting podcast a few years ago about truth and memory. And one of the examples they gave is that most people my age and older believe they remember exactly where they were on 9/11 and when they heard the news and what they did. And people feel like they remember those few hours. And in instances where they've been able to go back and verify things, people are wrong. But they just have this very clear memory of exactly where they were when it happened. And so just because someone is telling you something that you know can't be true, it doesn't necessarily mean they're lying, because memory gets shaped and warped in all kinds of ways. And so, helping your witness realize what is true and what maybe they misremembered, I think is an appropriate function. Pushing them to say something untrue is different.
I like Lindsay's term of their truth because, like I say, they could pass a lie detector and they could be 100% wrong. So I think that's the way it's going to come out. And the lawsuits we handle are almost all shades of gray. We don't handle many suits on a note, they're relatively easy. And as a result of that, you're just going to have to let people tell their story.
Can I add one other thing, Cassie? I have on occasion hired witness prep professionals when my witness is particularly bad or if it's a particularly important case. And they can be helpful. They can take your D witness to a B-, maybe. Maybe I'm hiring a better guy than you, Robert.
Yeah, I'll get the
You may
recommendation
have. That would not have been hard.
But you have to be really careful that they're not crossing the line in prepping your witness, because you can't hire someone to do something that you couldn't do yourself. So just the fact that it's not you saying it doesn't let you off the hook. And I've seen one witness prep person in this town who I think he crosses the line in teaching witnesses to be obstructionist. He's like, your goal is to never answer a question or, never give them a sound bite that they could use against you. So if it's, I don't recall, or it depends, or, whatever is the response, they're really teaching them don't give meaningful responses, which I think is over the line. So you have to be careful when you hire someone to help you that they're not doing something you wouldn't do.
I have also heard of folks encouraging their witnesses never to answer a question with a yes or no, even if a yes or no could answer the question. I see from Robert's head shaking and Paul's face that is not acceptable over the line advice.
The thing that we tell everybody that's deposed is the goal is to make this as short as possible. You're not going to win. The best you can do is a tie. And every extra word you put in an answer is that much longer this deposition lasts than it needed to. And so if you can answer yes, no, I don't know, or I don't remember, do that, because we don't want this deposition to be any longer than necessary. I do not understand instructions to the contrary to that. That is a
Yeah.
prescription for disaster.
It's not an ethical issue, it's a strategy issue.
It-
It's bad strategy.
It's
Honestly,
terrible.
Possible, if it's, can be honest. I mean, you can answer honestly either way, but better is, sometimes is yes or no.
Almost always.
So Lindsay, let me turn to you before we leave the topic of preparation. So we have been talking, I think, generally about fact witnesses, but many of us will defend and prepare corporate representatives or 30B6 witnesses. And so I was hopeful that you would be able to touch on your obligations to each type of witness and any differences that you might see in the prep.
Yeah, so I'll talk specifically about a corporate representative. So, if you get a notice for a corporate representative, and then of course the procedure, whether you're under federal 30B6 or you're under the Texas rules 199, the procedure there is the requesting party is supposed to send you topics, and then you review with your client and you figure out who the corporate representative should be. If the requesting party sends you a notice with a name as a corporate representative, which I've had other lawyers do, that's not proper procedure. But then your job is to help the company entity identify who the corporate representative should be for that testimony. And it's not necessarily the person that's most knowledgeable about all the topics, because these topics can cover a broad range of years and areas of testimony. But you want to identify someone who's going to speak on behalf of the organization, who's going to present well, and who can, gather information to be responsive to the questions. And so that's an important task. And of course, you can have more than one corporate representative, but you want to try to have consistency in the testimony for the corporation where you can. And then that person and your job is to help that person be prepared to testify. That's a different role than just tell me what you remember. You need to go educate yourself on these topics that we've agreed to. Of course, you may object to some of the topics that are presented, but you're helping that person educate themselves. So that's looking at documents, that's talking to other people as necessary for that person to be educated on their testimony. And so, a lot of times you take corporate representative depositions and the witness has done no preparation. They're just testifying more off their memory, which is not the role of a corporate representative. So that's really your role, is to help them get ready with that specific task and to know that they're speaking on behalf of the organization.
And just considering that, and Lindsay, if you have an answer to this or anyone else wants to jump in here, is there a difference in the way you help them craft and prepare their testimony? Understanding that, are your ethical obligations different, or your obligations to your client different here? Are you suggesting answers and responses because these are not necessarily the people that are the most factually educated? Just is the line different here for a corporate representative?
I don't know that that I would say your ethical responsibilities change, but I think the role changes, the role of the witness and the role of you guiding them in their preparation, because they are, like I said, responsible for educating themselves and being prepared to testify on the topics. And so there's more preparation that goes into that deposition. And from their end, they need to be prepared to testify on behalf of the organization, not this is what I think, this is my recollection, but be prepared to testify on behalf of the organization. And that's a distinction that is sometimes difficult for witnesses to understand.
This is a super dangerous area, especially when you have a situation where the primary spokesperson for the organization is also a key fact witness. And a lot of times what you'll see is the lawyer on the other side will want to depose that individual and that individual as the corporate representative at the same time. And then if that individual were to say, I don't know, in response to a question that the organization would absolutely know, that's an ethical issue then. It becomes a huge problem. And then what do you do as a lawyer to get the corporation out of the bind of having answered, I don't know, to a critical question? It is a super dangerous area. And not enough thought goes into who is the best person to testify on behalf of the organization a lot of times. It's a trap that's real easy to fall into, because it's real easy to say, okay, well, this person was actually involved in the transaction. Let's say they're the natural corporate representative. Well, maybe they're not. And so just kind of as a practice pointer, make sure if you've got an in-house counsel to deal with, go over these sorts of issues with the in-house lawyer, because there may be ways to avoid that. And I've seen lawyers get designated as the corporate representative sometimes. That can be a problem with the privilege, but be prepared to be creative with who it is the actual face of the organization at this deposition. So I bet every one of us has seen nightmare scenarios with this, because it happens.
Yeah, and if they are being deposed individually and as a corporate representative, you really have to be on guard to make sure the questions are understood. Are you asking this in the individual capacity or in the representative capacity? Because often those lines get blurred during the deposition, and you get an answer from the witness who, to Robert's point, is a key fact witness, but is that person answering that question individually or on behalf of the entity?
Yeah, be wary at the beginning of the deposition where the other lawyer may say, well, Mr. Jones, can I assume that this testimony is on behalf of the corporation unless you tell me otherwise? And if Mr. Jones says, okay, well, then that's another trick, another trap that you're potentially going to fall into. If Mr. Jones gives a bad answer on behalf of the corporation and says, no, that's just me saying that, it's not the corporation saying that. So Lindsay's right. You've got to be your antenna have to be up from the first question to the very last one.
And so shifting gears a little bit, I want to talk about a situation that came up in Kelly's story that she told, which is, and this is, a question about representing witnesses or simply defending their deposition. So the situation that we're in is that you have been retained to prepare and defend the deposition of an employee of a company that you represent. You represent the company. You are only defending the deposition of that employee. You are not representing that witness. And so, Kelly, I want to go to you. Is there a difference in the responsibilities that you have during preparation or in the your ethical obligations if you're just simply preparing this witness and defending? What warnings do you need to give them? What changes?
Yeah, I think the first thing is to be really clear that the witness understands that you don't represent them. If that's what you've decided. And like I said, you should think about this and make a decision, before you get into the room. Am I representing this witness, or am I just preparing them as an employee of my client? And once you make that decision, you need to make sure they understand it, because, particularly witnesses that are not very unsophisticated, if a lawyer comes in and spends the day with them, preparing them for their deposition, they're absolutely going to think that lawyer represents them. And in terms of your obligations, you owe ethical obligations and fiduciary duties to your client. You don't owe those duties to a witness that you're just preparing for deposition. And so, you need to be thinking, you need to make sure that the witness understands you may not be looking out for their best interest. You're looking out for the interest of your client. And so that could come up in any number of ways. For example, what if the witness is going to say something that helps your client and might not help the witness? The witness is going to take responsibility for something, for example. If you're only representing the company, then maybe you don't say anything. That's a win. But if there's an argument to be made that you're representing that witness, then you've got to advise them about their potential responsibility, their potential liability. And so it's just something you need to think through, and also think through the privilege issues, because a lot of people will just jump in and say, I'm representing the witness, because they want everything to be privileged. That creates conflict of interest issues, because then you've got joint clients and you probably haven't dealt with that with an engagement letter that waives conflicts and all the things that you would do if you were truly representing multiple parties. But you can get the same privilege benefit a lot of times, even without representing that person, because the privilege rule in Texas applies to clients and client representatives. And so if you look at the definition of client representatives, a lot of times those witnesses are going to fit within the definition of a client rep, and those conversations will be privileged anyway. Sometimes they may not. If they're really low level, just fact witnesses, there might not be a privilege. And in that circumstance, you need to be careful about what you say to that witness, knowing that it may not be privileged. So it's just all sorts of moving pieces that you need to think through before you're caught in the moment, unawares.
And just as a follow-up to that, get help on these situations. This is not easy stuff. This is hard stuff. If you've got, a managing partner who's running the case, ask he or she what to do about this. In-house counsel, if you're representing an organization and this is an employee, in-house counsel, you've got to keep them informed because they've got to keep the management team informed. So it's real important that you don't just make these decisions without getting help if help is available, because this is tricky again.
Let me add
Yeah,
one
I mean,
thing. Oh, go ahead.
I was going to say it's so tricky that very high profile lawyers get in trouble for this. During the Jerry Sandusky trial, there was a big issue about whether the Penn State lawyer was representing him personally or just representing the college. And it was in the news, is embarrassing for her. So it's not just young lawyers that make these mistakes.
And Paul, you were going to say?
She was in fact disbarred because of that. And a number of other lawyers have been disbarred because of this situation, because it can be so serious. My suggestion is when you have to deal with the employees or representatives, to make the written warning. They call this the corporate Miranda warning, to tell them that you're not representing them individually, if that's the case. And if you can't do it in writing, because they won't remember a simple oral warning when it comes to it later, and they've now been fired from the company because they admitted to use something that they didn't want the company to know.
Or maybe they've been indicted.
Or maybe they've been indicted. That's happened also. Yeah. And if you can't get it in writing, or if you're not going to get it in writing, at least have another lawyer there to witness you giving the warning, so that you've got two against one, because it's real important that warning be given.
Yeah, and I think, a lot of these things seem natural to sort of each of you on the panel because you have such a breadth and depth of experience. But for lawyers that are just starting, when you get that assignment of, all right, prep this witness and go defend their deposition, if these things aren't always flagged for you, they're not always front of mind. And it's helpful to hear, I think, all of this from each of you. So,
Yeah, and I was just gonna add, Cassie, to Kelly's point, if you decide you're representing both the witness and the entity, and you go through the process of a joint representation, just know then that, if something comes up that's conflicting between the individual and the entity, most of the times, that can be dealt with. And that's not unusual to have different recollections from different witnesses, but that's just something you need to be aware of, because if it rises to the level of a true conflict and it's not waivable, then you can't continue with that joint representation.
And sometimes that'll happen in the middle of the deposition,
Right.
which is that's a very bad moment when that happens.
And let me just ask, let me short circuit, because I do want to make sure we get to touch on our next topic, but Robert or Lindsay, if you can have the final word here on when that does come up in a deposition, when a witness suddenly says something either different than they said during prep, or that you just didn't think to ask, and all of a sudden there's a conflict. What do you do in that situation? What can you do?
If there's a conflict, you have to terminate the deposition at that moment. You cannot go forward.
that's all the more reason for really thorough prep to make sure you, as much as you can, you get those issues out before the deposition, because you'd much rather handle that in advance than during.
And so moving on to scary things that happen during deposition. Paul, I would really appreciate if you could walk us through Texas Ethics Opinion 692, which I believe that you had a hand in authoring. So if you could, I would appreciate it.
They didn't have a hand in authoring it, but it is by the committee that.
Then never mind. Just kidding.
I can't explain it. It's probably the most controversial opinion that the committee has authored in the last few years, judging by reactions from people. And let me give you the basic scenario. The scenario is that you have a client that's been involved in an automobile accident, and in your initial meetings or in your prep session, the client says, you ask him whether he was looking at his phone right before the accident. The client says, yeah, I was, but the other person was driving like a maniac and it's his fault. So you go into the deposition. The deposition is being taken by the other party, and the other party's lawyer asks your client whether he was looking at his phone, and your client says, no, I was not looking at my phone. And so you know that your client has lied in the deposition, but you did not ask the question. And the reason this becomes complicated from an ethics standpoint is because as lawyers, we have these duties of confidentiality to the client and duties to represent them zealously versus a duty of candor to the court, usually the court, and sometimes to other parties. And so the question is, how does that come out here? You've heard your client lie in a deposition. And the answer is kind of surprising under the Texas rules, the way they're currently drafted. Part of the reason we write some of these opinions is to let the people that review and revise the rules know that there's a bit of a problem, because this would not happen under the rules of most other states or under the ABA. But basically, the answer is that in this situation, what you do is you have to go back with your witness and confront them and urge them to correct their testimony. But if the client says, no, I'm not going to go back there, and by the way, don't you tell anybody that I've lied. You are obligated under Texas rules to follow that instruction, provided that, and these are important provisos, you don't elicit the testimony from the client. You don't try to use it in court, and the client doesn't testify to it in court. If your client lies in court as opposed to a deposition where he's being asked by the other party, then that's a totally different situation, and you have duties that arise from that to possibly advise the court. But this opinion is limited to the situation where it's in a deposition. The witness is asked by the opposing party, not by the lawyer for the witness, and the witness lies only in the deposition. So that's the situation there, and that makes me want to remind everybody as well, bigger picture. The rules on the ethics of depositions, deposition preparation, are similar in most jurisdictions, but they are not at all the same. And as examples of that, the rules about, for example, what you can say to a witness during a conference, during a break in Texas are different than other places. Whether you can instruct a witness to not answer a question beyond an instruction on privilege is different in Texas than in most other jurisdictions. So there are different things. If you're in a different state, in a case in a different state, you need to be familiar with the differences in the rules. But that's a different issue. Back to opinion 692, that was pretty much a summary. it doesn't sound right, it doesn't feel right, that you can keep confidential the fact that your client has lied in a deposition, but there's a comment in the rules that makes it almost impossible to reach a different conclusion. So maybe that'll get changed in the future.
Well, let me do, unless Robert, Lindsay, or Kelly has a reaction to opinion 692, I have a rapid fire ending round, and then we will conclude the CLE. So Robert, Lindsay, Kelly, if you have anything that you want to add on 692, I'd love to hear
I hate that opinion. But,
it.
and I think the practice pointer there is when the client lies and there's a break, you've got to tell the client that if the truth comes out, you are toast. And so you're better off to tell the truth right now and get this cleared up than hope it never gets discovered and maybe we settle this case. But if we go to trial, it's going to come out and you will get the book thrown at you, proverbial. So,
Fine.
I mean, I just don't think the opinion hammers home hard enough how hard, from a practical standpoint, you need to lean on the client to tell the truth.
Well, and the practicality of continuing with the representation. I mean, with the limitations that Paul provided, that you can't use that testimony in court, you can't rely on it. It's very difficult to represent that client going forward. And so you're likely looking at a withdrawal situation after the deposition. So I understand the opinion and the way that it's written, but I think in practical terms, it's very difficult to live with.
But if
Alright.
you withdraw and they get a new lawyer, that lawyer may not know it's a lie. And so they may
That may
use
be
it in
their
their summary
fault.
judgment.
Yeah.
Yeah.
Oh, the ethical landmines of being a lawyer are so fun. Kelly, let me start with a rapid fire question for you. You've got a combative attorney in a deposition. He immediately threatens to call the judge, is talking over the witness, interrupting the witness in a clear way where you're defending, attempting to intimidate or bully the both of you. In 30 seconds, what is the best tactic to deal with that situation?
I always try to be the most reasonable person in the room and just build a good record. And if you rise to the bait, it's just gonna escalate and both of you are gonna look like fools if you have to take it to the court. And so stay calm, build a good record that they're being obstructionist, and decide if you have to take it to the court later.
Paul, you have a witness who, much like the situation you described, has absolutely no memory of anything. They don't have a specific memory and they barely have a general one. How do you build your record? What do you do during the deposition in 30 seconds?
Well, I think that comes up, that happens a lot. Also, you have a witness who can remember one specific thing 10 years ago and can't remember anything else. It's equally suspicious. What you need to do in either case is to build a record to make it look obvious that the person is using "I don't remember" as a tactic, and by asking a long series of questions to show the court that the person is not remembering even the most ridiculously memorable things. But that's really all you can do.
So don't get intimidated in the face if I don't remember. Keep asking your questions. Keep building your record. Because I feel like sometimes people, when you're younger, you want to back down or give it up. The advice from Paul is don't do that. Lindsay, really long speaking objections they insist on making. They won't agree to a standing objection to form. What do you do?
Yeah, so you just make your record. You need to object on the record to the speaking objection. I always say, particularly to young lawyers, come prepared with the rules, cite the rules, pull out your rule book, because they are what they are. They're very clear. Those objections are not proper and they can really derail the deposition. So make your objections, cite the rules, and hopefully you can get to a place where you can continue with the deposition.
Quick aside, do you think it's all right or appropriate to say, I hear your speaking objections. I think at this point they're influencing the witness's testimony. Do you want that on the record? Is that what you want to say?
If that's what they're doing, then I think you state that on the record. You be as clear as you can and you cite to the rules so that you've made your record on that issue.
All right, Robert, my very last question to you, sir. Nonverbal cues. We've got pen tapping. We've got eyebrow raising. We've got head nods of sorts. What do you do? How do you deal with it?
You mean this for yes and this for no?
They are serious baseball fans.
Yeah. Well, in the days of in-person depositions, that was much harder to get away with. You could usually spot it if the lawyer is kicking the witness under the table and things like that. With remote depositions, that's become a much bigger problem. So you've got to ask upfront, who's in the room with you? Does the lawyer have your cell number? You know, ask those kinds of questions to make the lawyer on the other side perhaps a little nervous about being tempted to send a text or an email or a phone call during breaks or even during the deposition, interrupt it if you're doing well. So it's harder now, but look for patterns. You know, if you see some patterns, strange patterns in the answers where you're on a topic and I don't know start coming out or no's start coming out, but it's hard when you're young and you haven't been through it before, but you've just got to look for all those things. And it's gotten much harder with remote depots than it used to be.
So I want to say thank you so much to all of our panelists. The CLE code is in the chat. I cannot say it or something happens with the credit for the program. So it's in the chat. Please look in the chat. I just want to say again, Robert, Lindsay, Kelly, Paul, I had not met most of you when I asked you to do the panel. Y'all have such a breadth of experience, and we're so lucky that you dedicated your time to help all of our young lawyers in Dallas and beyond be their very best selves in depositions, stick to their ethical obligations, and do their very best for their clients. I sincerely hope to never be a client of yours, but I do just very much appreciate each of you, and thank you so much on behalf of myself, DAYL, and all of the attendees that we had today.
You.
Thanks, Cassie.
Yeah, thanks. for
Bye,
having me.
y'all.